Good afternoon. My name is Milbree Rainey, and I'm the Assistant Director of the Children's Commission. On behalf of the Commission, I'd like to welcome you to today's webinar entitled Utilizing Court Interpreters in Child Welfare Cases. Our speakers for today's presentation will be the Honorable Charles Griffin, Judge of the Gulf Coast Children's Court, who will also serve as our moderator. Leo Perales, Court Services Manager for Court Reporters and Interpreters at the Texas Office of the Court Administration. And Damaris Chavez, Attorney at Law at the Law Office of Damaris Chavez. This webinar will address best practices for including court interpreters throughout a child welfare case. The presentation will cover related legal requirements, logistics, client communication, and courtroom dynamics. A PDF of the PowerPoint presentation will be made available on the Children's Commission On-Demand Training and MCLE webpage. For those watching the live presentation, the Q&A feature is available and questions will be answered at the end of the presentation if time allows. Additionally, the MCLE course number will be provided at the end of the presentation. If you're watching the webinar replay, you may email cctraining@texcourts.gov for MCLE self-reporting information. And it's now my pleasure to turn it over to our judicial moderator, Judge Charles Griffin.
Good afternoon, everyone, and welcome to Utilizing Court Interpreters in Child Welfare Cases. My name is Charles Griffin. I'm the Associate Judge of the Gulf Coast Children's Court. Our court hears child welfare cases in Harris and Matagorda counties. Joining me today, I have two esteemed panelists, Damaris Chavez and Leo Perales. Would each of you take just a minute to introduce yourselves, beginning with Damaris, and Leo, after you've introduced yourself, if you'd give us a quick overview of what we plan to talk about today. Damaris?
Thank you, Judge. Hi all, my name is Damaris Chavez, and I am a licensed attorney for 10 years, primarily practicing in the areas of family law and child welfare. And I'm very excited to be here and presenting with you.
Good afternoon. My name is Leo Perales. I've been in the working with the Office of Court Administration since 2014, and I'm very glad to be here to discuss this information with you. What we'll be discussing during this presentation is broken into three parts. First, we'll discuss the legal foundations, state laws governing language access and interpreters. Then we'll pivot over to what are the requirements and correct protocols of a court interpreter. We understand you don't want to be an interpreter, but it's good to know what to look for in an interpreter to make sure you're using a qualified one. And finally, we'll have discussions from attorneys and judges on best practices on using interpreters in the courtroom.
So let's dive right in, beginning with legal foundations. Leo?
So first of all, what we want to understand is what's the difference between an interpreter and a translator. During the presentation, you'll come to see that words do matter. So that depending on what service you're wanting to request, we do want to make sure that you use the correct terminology. There's a difference between an interpreter and a translator. As you can see here, we put the little visuals. An interpreter deals with the spoken word, and a translator deals with the written word. The reason this is important is because some interpreters some translators do not work as interpreters in court. They're strictly at their computer translating manuals or contracts into other languages. So there is a difference. The next question that may come up is, when is a spoken or sign language interpreter appointed by the court? We'll go into the statute. So Texas Government Code 57.002, it's like a two-tier. The first part of the code says a court shall appoint an interpreter if either a party needs it or a witness needs it in a civil or criminal proceeding. Now, this is important because the shall applies to the actual parties in a case or a witness. If we don't have an interpreter for these very important people in a case, then we don't understand, the record can't be clear. So you'll notice here it says shall. The next portion says a court may appoint an interpreter on its own motion for a person with limited English proficiency. What this basically applies to is, let's say we have in a juvenile case where the court wants to make sure that the parents know and understand what the juvenile is going to have to do in his case, well, there it is. Mom or dad is not necessarily a party. They're not a witness. They're just another person. So that's why the statute says that a court may appoint an interpreter. So in the next slide, we kind of give a summary, a complete summary of what the government code says. Chapter 57.002. We got the subsection A, subsection B, and then B1. Now, last legislative session, during the 88th legislative session, there were changes to Government Code 57.002 because when competent interpreters aren't used, then that's actually affecting their legal rights, and the court can't make all those correct findings. So these are the changes that happened. Under the next slide, you'll notice that the law was changed to add subsection G. What it basically says is now, if a party files a statement of inability to afford payment of court costs under Rule 145 civil procedure, basically what that means is now the court must provide the court interpreters free of charge. And this was a clarification. It was not a modification of the government code. It simply clarified that an indigent party should also receive the interpreting services free of charge. This rule does apply to all of the county and district courts in the state of Texas. So now that we understand what the law says and the statutes about using interpreters, one thing we want to make sure is that the courts and the attorneys procure the most qualified interpreter that we can find. Now, in the very last paragraph of this slide, how do we know if someone is qualified? It would be a good idea to ask, for example, their ability to speak the language they're asking to interpret in. How long have they spoken the language? That way, the court can gauge, or even the attorneys can gauge, how qualified they are. Now, the next question would be, does the interpreter have to be licensed? In the next slide, we include Government Code 57.002 subsection C and D. And what this basically means is it depends on if you're in a big county with a large population or a rural county with a lower population. We'll work in reverse. You'll notice on the right-hand side of this slide, if you are in a county with a population of over 50,000, then for Spanish, you must use a licensed court interpreter. The court must use a licensed court interpreter. And if it's for any other language, and if you cannot locate that interpreter for the other language within a 75-mile radius of the court, then you can use an unlicensed interpreter. Notice the left-hand side as well. Now, these are for rural counties or smaller counties. The statute does clarify that in counties with population of under 50,000, the interpreter does not have to be licensed. However, it's important that you do use the most qualified interpreter possible. That's why we included the information in the prior slide about how to qualify the interpreter. But regarding these smaller counties, the next slide discusses a few more requirements when you are going to use an interpreter that is not licensed. It's a three-part rule. First off, that interpreter must be qualified as an expert under the Texas Rules of Evidence. You attorneys will know what that means. They also have to be at least 18 years of age, and they cannot be a party to the proceeding. If that interpreter falls within these three requirements, and if you are in a county with a population of under 50,000, then you can use that unlicensed interpreter. There are a few exceptions, additional exceptions. In certain border counties under Civil Practice and Remedies Code Chapter 21, For Spanish language interpreters, the only requirement, according to statute, is that the person be well-versed and competent to speak the Spanish and English language. That's what the statute says, and I always include this information in there. These are for certain border counties. So now that we've discussed all this, what's the difference between these licensed interpreters and certified interpreters? Because you will notice 57.002 does use both these terms. And it's right here on the left-hand side. The term certified court interpreter applies specifically for an individual who has a hearing impairment. So a certified interpreter applies to the sign language interpreters. And on the right side, for a person who needs to understand the English language, then they use the term licensed court interpreters. Now, why is this important? This is important because, once again, words matter. If the court is going to request a specific interpreter for Spanish, for example, and you use, I need a certified interpreter, there really isn't a certifying body. There is a license, a state agency that issues licenses. So words do matter, and you do want to use the correct terminology. And finally, who can act as a sign language interpreter? Once again, we also included the information in the same Chapter 57.021. The department shall certify interpreters so that they can interpret in court. The department can contract with public or private institutions to administer this type of a program, and the department shall maintain a list of certified interpreters. Remember, we're talking about certified interpreters. That's ASL interpreters. And more, we have some information on where to find those list of interpreters in this presentation.
So let's move forward and talk a little more about licensing requirements and proper protocols in the courtroom. Leo, what sort of training and testing does someone have to go through to become a licensed court interpreter?
Correct. In summary, it's simply a four steps. One, the interpreter has to complete an orientation course, and that's more of an immersion course to let the interpreter know what happens in court. After they complete that orientation course, then they have to submit an application and pay the fees. Then they pass a background check. And finally, they can take the test. The test is a two-part test, kind of like a bifurcated test. First, you have to pass the written exam. The written exam is actually a multiple choice test of about 180 questions, and it has to do with vocabulary term usage, ethics, and professional conduct. If the candidate successfully passes the written exam, then they now can take the oral examination, which measures their proficiency in consecutive and simultaneous interpretation. Now, now that we're discussing in this second part of the presentation about, so we discussed the licensing requirements. Now, the correct protocols in the courtroom. We did include some information on the code of ethics, but now, what type of things are you wanting to see or expecting to see when you to know if you got a qualified interpreter? Well, for example, here, the court interpreter, in accordance with his standard of ethics, has to interpret everything without omitting or embellishing. They also have to conserve the register and style and the tone of the language that the limited English proficient person is using. They have to also use the same grammatical structure as the person who's speaking. We'll go into more details in the additional slides, and they have to correct the record if they see any errors in his or her own interpretation as soon as possible. Now, we include this information, we put verbatim with a little X. please know that the court interpreters, while we would like a court interpreter to interpret verbatim, that generally doesn't happen. Now, hear me out. The reason it doesn't happen is not that they're interpreting incorrectly. It's because it's impossible at times to interpret verbatim what is being said. And you can see some examples here. Because a lot of times we hear from the judge or from the attorneys, all we want you to do is interpret verbatim. But you can see here, it may not make sense. Here's a Spanish example. Specifically, the second sentence that you see here, ser un cero a la izquierda. Literally, verbatim translates to be a zero to the left. Now, what does that mean? Well, to be a zero to the left doesn't make sense in English, from Spanish into English. But if someone uses it in context, it'll mean, well, he's a worthless person or he's a nobody. And that is what a court interpreter does in their daily activities.
And sometimes the interpretation needs vary by county, Damaris?
Yes, absolutely. Each county has their own interpretation needs depending on their population. But for example, language needs vary by region. Harris and Fort Bend counties, we have a lot of Spanish-speaking, Vietnamese, Chinese people that need interpretation. Bexar County, Spanish and German. And now we're getting a lot of the different languages from other countries as well. I, in my practice, have experienced with different languages from Guatemala. Quechua, Quiche, and Mam have been three that I have experienced with, and those were very interesting cases, but also very hard to work with because there are not many interpreters available for those languages.
Let's talk a little bit more about protocols. Can you talk, Leo or Damaris, tell us a little bit about filler words?
Correct. Well, so filler words, a court interpreter, whenever they're interpreting, they even have to include all those filler words. Now, a lot of times you do see that hesitation in a witness, and they'll use, I'm really not sure. I guess so. All of those are preserved during the interpretation. So one of the proper interpreter protocols is that all of those little filler words are conserved for the record by the interpreter. So it's not that the interpreter is not doing their job or they're hesitating. They're literally including what the witness said in their language into Spanish, including these filler words.
What about repetition?
Repetitions are also included. For example, if a witness says, no, I didn't see that. In Spanish, that will be conserved. They will never just condense it and just clean up the testimony, so to speak, and just say, I didn't see him. All of those repeater words that the witness used, even if it was repetition, those are also included and conserved for the record.
Okay. And sometimes we use a lot of legalese. Well, we use a lot of legalese in the courtroom, and things can seem redundant. But what about repeating things, or does the translator, when it seems redundant, still repeat everything?
Yes, the redundancies are also conserved, and that's very important to make sure that the parent understands what is going on and what they have to do. We put an example here of the admonishments that a parent has to understand in a child protection case. For example, they may be subject to restriction or termination. Both of those two words mean two different things, and that has to be conserved into that language. willing and able to provide a safe environment. Those two words mean two different things. All of those redundancies, a court interpreter who's qualified does conserve that and doesn't just condense it and say, you may lose your rights to your child. No, there's many redundancies that have to be conserved.
And what about the level of language? Some lawyers and judges like to use nickel words. Do you use nickel words, or do you kind of use the words that you choose?
Well, on the register, I know Damaris here would definitely be interested. Whenever asking a question, they ask a question a certain way, right?
Yes, absolutely. And I think it's very important. All of these things that we've been talking about, it's because we're judging the credibility, right? And the character of the witness that is on the stand. So it is important to get the correct interpretation for the record, and including the register. I mean, you must convey the same level of language without altering the register. So the interpreter must interpret without changing the formality, the tone, the complexity of the original language. The message must remain clear, complex, simple, or technical as the original speaker intended it.
What if somebody curses?
If somebody curses, the interpreter does have to conserve those expletives. So exactly what is being heard, if that's what was said, that is also going to make it into the record, into the correct language.
And if the witness is showing emotion?
I believe that's very important to convey even the same emotions. The interpreter should strive to the element of emotion through moderate voice modulation. They should try to use the same type of tone. Now, obviously, the interpreter should not or refrain from being overly dramatic or adding their own emotions, but I think that emotions absolutely matter.
Okay. And what if the judge gets upset and starts waving their hands wildly? Does the interpreter also use the gestures the judge is using?
Well, no, that's definitely the interpreter does not become the center of attention. Gestures made by a witness generally are not reproduced, and then the judge will make sure that all that's preserved in the record.
Anything else you want to talk about on gestures?
Aside from this, during a very long question and answer session, even the interpreter should never show any frustration. A lot of times, a witness may not answer the question correctly, and it seems like we're going around in circles. But the interpreter should never make any eye rolls of frustration whenever the witness doesn't answer, or any type of hand motions. So these are things that an interpreter should and should not do.
Okay. Let's move forward a little bit and talk about the modes of interpreting. Leo, can you tell us a little bit about that?
Yes, there are two modes of interpreting. There's either simultaneous interpreting or consecutive interpreting. And the key, and one would ask, well, how do we know which one he or she should be using? Whenever the person who needs the interpreter is just passively listening, where they're not being asked a question and nobody needs to know what that person is, what the Spanish speaker, for example, or the Vietnamese speaker is saying, they're just listening to testimony. That's when the interpreter simultaneously interprets for them, either by ways of headsets or sitting next to them and whispering in their ear. But nobody else needs to hear what the interpreter is interpreting except that simultaneous for that person. The flip side is once they're actually sitting on the stand, kind of like in a deposition or witness testimony, that's when the interpreter switches into a consecutive interpreting, meaning question, wait, interpret, answer, wait, interpret, next question, like a deposition back and forth. That's consecutive interpreting. And those are the two modes of interpreting used in standard in court interpreting.
Okay. So let's move forward to the third section of our presentation, the best practices for judges, attorneys, and logistics. Damaris, based on your experience, what are some good practices?
I believe that one of the first things is knowing whether your client needs an interpreter. I think it's important to know ahead of time so that you can schedule the interpreter weeks in advance or months in advance. You don't want to wait till the last minute because then an interpreter may not be available and you may not be able to have your hearing.
Right. And if I could chime in a little bit on the scheduling, it's kind of problematic for courts. What happens oftentimes is that we're notified, not oftentimes, I don't want to over exaggerate, but we're a lot of the times notified 5 minutes before court that a translation service is needed. And it's very difficult. If attorneys would let us know a couple of days in advance so that we can schedule and have an interpreter here, that's always best. If you don't do it in advance, you run the risk of the possibility that we may have to reset the hearing because the translator's not available. Any other helpful tips, Damaris?
I think it's also important to know what their minimum fee is. Of course, if your client is indigent, then you know that the translator will be covered or their fees will be covered by the court. However, there are times in CPS cases where you have interveners and you may be representing an intervener and nobody else may have an interpreter. And if the intervener is not found indigent, they will be responsible for paying their own interpreter fees. So it's important to ask what those fees are. Some of them have an either 2 or 3 hour or half day minimum fee that you will have to pay. So that is something to know ahead of time so that you can prepare your client for the cost as well.
What about idle times?
Time also, it's important because interpreters have other matters that they need to also be at other courts. So it's important to know what times they are available and what span of time you have. Because in cases where an interpreter is needed, it may take longer than a regular case, right? So it's important to know, what is the time limitation for the interpreter and also how much time you're going to get from the court.
Right. Certainly get maybe a set time from the court. A lot of courts do what I call cattle calls. They will show up all at one time. We do that particularly in Harris County. And if you've got an interpreter that's just kind of hanging around, that's a waste of resources. So you certainly want to get a set time. Something else I hadn't considered before we started working on this presentation was coordinating with other courts. I recently took this tip, Leo gave this tip, and I hadn't thought about it before then, but trying to coordinate with other courts when you're using a translator. I actually used it for a court reporter, and that worked out quite well. The court reporter billed for the half day when I was done within 30 minutes. Other courts were able to utilize it. And I would think that same principle would be able to apply to translators as well. There was another thing that I hadn't considered before working on this presentation. Anybody who's worked with me more than 5 minutes knows that I can talk fast and furious, and I can go hours in between breaks. So, Leo, can you tell me a little bit about what we can do to avoid wearing out the interpreter and ensuring accuracy?
Sure. So a court interpreter, if they take an assignment during a long hearing or a long trial, it is a good practice to hire a second interpreter so that they can switch, so that the interpreters can switch off every 45 minutes to an hour, and that way they avoid the fatigue. Because what their mind is doing, they're listening, they're processing, and they're interpreting all at the same time. Those are about 3 or 4 tasks that the interpreter does, and it's nonstop. So about 30 to 45 minutes, the interpreter starts getting fatigued. And if we use a team of interpreters, that second interpreter will immediately take over. Now, then once the first interpreter is not interpreting, it doesn't mean that they just leave and not do anything. They're sitting next to the main interpreter and they're assisting in any way finding words, terminology, anything to help each other. So it is a good practice whenever anything is going to be longer than 2 hours to use a team of interpreters. And in the next slide, we did include the nationally recognized official paper that discusses more in detail why team interpreting is important in courts.
Damaris, do you have some other tips you'd like to give?
Well, we also have our next slide about best practices for hearings. Like we said, it's important to know ahead of time that an interpreter is needed and provide that notice to the court so that they have or they coordinate with an interpreter on the day of. And also, prior to the hearing, it's important to call the court and schedule time so that they can check the interpretation service and make sure that it is ready and that your client knows how to access the interpretation services. Some courts are utilizing the interpretation or language interpretation mode on the Zoom app. And that is something that not all the courts use, but it's a great resource to be able to have that so that they can do the simultaneous interpretation. But the rest of the people that are in the English channel don't necessarily have to hear the interpretation. But that needs to be arranged ahead of time because that does take some steps and not everybody knows how to get there. And, everybody has issues with it, even attorneys do, judges do. So our clients need to be taught how to do that as well. So make arrangements with a court coordinator. Usually the court coordinator is the one who will schedule the interpreter and will be able to arrange that time. I've also seen some courts do interpretation simultaneously with an extra device. So if they have an additional phone that the clients can use, they can use their computer and do their Zoom there, but then have the interpreter on their secondary device on their phone. I have a court that does that and it works great. So other courts can provide an additional Zoom link to the attorneys so that they can share with their clients and the witnesses so that they can practice with the court coordinator. This is in the cases where courts only have one Zoom hearing per day. And they use that one Zoom hearing. So if they're using it throughout the day doing their docket, then the attorney's not able to log in prior to the hearing to practice or to make sure that it's working because court is doing their docket at that time. So an additional Zoom link can be requested from the court coordinator to do that. And Judge, you can talk about what judges do.
I think that last point is a great tip. By the way, in our court, we typically use one Zoom link for each setting. So we may have an entire docket. We use one Zoom link on it. And it's difficult when you're using a translation service to have the translator and their team practice beforehand. And it can eat up a lot of court time once you start the hearing, trying to set up the service and get people kind of rocking and rolling. So I think that if you're going to do a virtual hearing, coming up with a secondary Zoom link and letting people practice and kind of getting things set up before the actual hearing starts while the judge or the court is handling other business is a great tip. To the judges and the coordinators that are out there, when you have a case with an interpreter on it, you always want to allocate more time. A good rule of thumb for us is about 15 minutes. We will give, to kind of get things set up and get people positioned and ready to go. Generally takes about 15 minutes to do it. Something, again, I hadn't thought about. Some of our hearings can be longer, 30, 45 minutes up to an hour. Judges should be mindful of fatigue. Watch the interpreter. Don't try to get the interpreter to throw his or her hands up in the air and by talking fast, if they seem to be getting tired, make sure that you give them breaks. And every once in a while, we get an attorney who makes an objection to the interpretation. I wish that I was bilingual and understood some of the Spanish, but I don't. But I know that many of our lawyers out there do, and it's not uncommon for me to for an objection to be drawn if the lawyers don't hear a word for word translation, and sometimes they have concerns about how the interpreter is doing their job. And to the judges, I would say consider allowing the attorney to take the interpreter on voir dire and hear any objections after that. Let's move on to other considerations. Damaris, you mentioned a moment ago secondary devices. Is there any pitfalls of using a secondary device?
Well, I think that when you're using a secondary device, one of the pitfalls is that a person may not have a secondary device. And that happens a lot in our CPS cases. Most parents log on their phones. So the courts that use the interpreters and that call the clients on their phone, then they can no longer be on the Zoom where you can see them on their video. So that creates a problem of credibility, because then you are not able to see the witness, and you're not able to judge their credibility and see what they're doing, see who they're talking to. That has also caused a lot of issues. We have a lot of people that are in the room with other people that are telling them what to say. So that's something that you may want to consider when having a secondary device, which is why it may be important then to consider having the witness be present in the courtroom, so that the witness is able to be their credibility is able to be judged in person. Okay.
And if I could just chime in there, sometimes having the witness in the courtroom is it's easier to troubleshoot the issues. Our court uses the OCA service quite a bit. We have seen Spanish speakers in particular, not just Spanish speakers, but anybody using the translation service struggle with setting up the service on the computer. And sometimes having them in the live in the courtroom, we can put them in a different room and help them set up the translation service. So having the witnesses there in person is great. And I would imagine in any situation, having a client there that you can communicate with directly, having that extra barrier of it being online sometimes makes things a little more difficult than they need to be. Damaris, any final best practices you want to give?
Yes. I think it's also very important to confer ahead of time with the interpreter and the client, so that they can, that you can make sure that your client is going to appear and participate, right? It's very important in these CPS cases. Sometimes we don't have as much communication with our clients. But it's also important for the client to know that there will be an interpreter, and for them to at least know that there will be someone there, and hopefully they can meet and feel comfortable with each other. But also it's important for the attorney to prepare their client to speak slowly, to speak clearly and in shorter segments, so that their testimony can be interpreted correctly, and that the hearing can go smooth. It's also important for the attorney to consider waiting until after the interpreter has finished their interpretation to object, and then they can move to strike that from the record if they want to wait until after the interpreter finishes. There are times that I haven't waited because I understand Spanish and I know what the witness said, and I don't want that to come out. And so then I may object to non-responsive after, if they say yes, and then I'll just let the interpreter say yes, and everything else I say objection to everything after yes is non-responsive. So it really is up to the attorney how they want to handle that, whether you want to wait. I mean, if my client is saying something that I know I want them to say more of, and the interpreter is going to continue to interpret, and opposing counsel is not objecting, then I may just want to wait, right? So it really depends on the attorney. Okay, which is why it's important for you to consider, and for courts to consider too, appointing attorneys that speak the language of the clients, right? so that they can communicate with their clients and that they can understand whether their clients are getting an accurate interpretation. Okay. Another one too is attorneys that represent interveners or people that have private cases. You may want to keep a list of interpreters in the area, and so that you can call and their fees associated with and any time restraints that they have or any time limitations that they have, so that you can have an array of interpreters in case one is not available at the time that you need one, because it happens. It's happened to me a lot. It's very common, actually. Okay. Interpretation services outside of the courtroom. I've had cases where I don't necessarily speak the same language as the person. I've had cases where the person doesn't speak Spanish, but speaks Quechua or another Guatemalan language. And in those cases, I think it's important as an attorney to file a motion for the appointment of an interpreter, but also for the payment of the interpreter, and requesting that the interpretation be available outside of the court settings, so that you are able to confer with your client, so you're able to prepare your client. And the court can order the county to pay those out-of-court services if the client is found indigent in these child welfare cases. It's important to ask for that, so that you're able to have those meetings with your clients, and you're able to even speak to witnesses. If there are witnesses that you need to speak to that speak the language, you'll have the interpreter available for those times as well.
So, Leo Damaris, what if you want to use a recording in court? What are some of the pitfalls of that?
Well, from
Or
an
sound file?
interpreter,
Sorry.
yeah, from an interpreter standpoint, an interpreter interpreting a sound file just on the fly is bound to make mistakes, because just playing the whole video straight through, you haven't even heard what it says, you don't know what they're saying, and you're asked to interpret on the fly. Mistakes are bound to get into the record.
And yes, I think as an attorney, Texas Rule of Evidence 1009 specifically talks about translating foreign language documents. And I think this doesn't just encompasses just written materials. I think it's also any sound files as well. And a translation of a foreign language document is admissible if at least 45 days before the trial, the proponent serves on all the parties the translation of the underlying foreign language document and a qualified translator's affidavit or unsworn declaration that sets forth the translator's qualifications and certifies that the translation is accurate. So when that is filed 45 days prior to trial, then the opposing party can then object, right? They're able to specifically indicate the inaccuracies, if there are any inaccuracies in the translation, and offer an accurate translation. But they must serve the objection on all the parties 15 days before the trial. If the opposing party does not object, then the document or the sound file is otherwise admissible. Now, if there is an objection, then the court must determine whether there is a genuine issue about the accuracy of the material, and what is that is being what is the issue that is being litigated, and also the trier of fact must resolve the issue in that case. So that is how an attorney should handle. I would definitely not allow anything to be brought in that is not transcribed and it's in another language and asked the translator to do it there on the fly. I don't think it's I don't think it's a good idea.
Right. And then we included here once again, an official document that explains why this on-site, on the fly, if you will, simultaneous interpretation of a sound file is not recommended.
Leo, do you have any final tips?
Yeah, we have several resources for attorneys and judges to locate qualified interpreters. Now, the question always comes up is, well, okay, so I need an interpreter. Where do I find one? Well, this slide and all of these slides are designed so that you can print them out, put them in a manila envelope, and store them. And when you need them, you pull it out, and the information will likely be there as well. It's static information. This website, along with the QR code, has links on locating interpreters from the official state roster of court interpreters, and that information is there. Then we also included in the next slide, within the judiciary as well, txcourts.gov, our remote interpreter service. Now, this is for short, uncontested matters. The court staff is free to use OCA's remote interpreters in the languages that are indicated here at no cost for short hearings. Now, unfortunately, this service is not openly available to private attorneys, but if you do have a case that falls within, speak to the court staff and maybe they can reach out to OCA. We also included 2 associations, professional associations, one at the state level and one at the national level, where you'll find their directory of members who are interpreters that also include their languages. You'll be able to do a search just in case you need to find an interpreter in a different language. And the question always comes up about, well, how do I locate a sign language interpreter? Same information in the same format with the website and the QR code of the official database of state interpreters for sign language. Now, keep in mind also, whenever a court needs a sign language interpreter, that court interpreter has to have a court interpreter certification. When you click on that QR code, you'll see what I mean. Sign language interpreters have different types of designations. Some may only be able to interpret in doctor visits, or some may only be able to interpret in schools. But if they're for court, they have to have a court interpreter certification. As well, sometimes an interpreter is needed to provide CART services. That's like a real-time translation. That's basically, in layman's terms, a court reporter who's typing on the machine and putting out the captions for the court hearing. So although they're a court reporter, they're on the machine for that particular case. They are an interpreter because they're providing CART services for someone who is deaf or hard of hearing. And then at times we do get inquiries from judges about, well, what are recommended fees? Because the Civil Practice and Remedies Code does talk about it. We included this slide, and on the next slide, we even included the link and the QR code to the recommended fees for those that need an interpreter deaf or hard of hearing.
Okay, well, I think that's the end of our presentation. I know that's the end of our presentation. It looks like we have a time for a couple of questions. Milbury, do you have any questions?
Yes, Judge, thank you. We've got some great ones in the chat that I'll share with you now. The first one that came in is primarily, I think, a question for Leo, and it is, what languages currently have licensing requirements?
That's a very good question. The answer would be the languages that the National Center for State Court does provide certification tests for. That information is on www.txcourts.gov/JBCC. That stands for Judicial Branch Certification Commission. The languages are there in which they certify.
Thank you, Leo. We had another question come in fairly early on And the question is, does this apply to other languages or just Spanish? I'm not sure what slide that might relate to. Maybe it was about the border counties. Is there anything else you want to say about that, Leo?
Yeah, if it had to do about the border counties, the Texas Civil Practice and Remedies Code, Chapter 21, it does apply only for Spanish. So if in certain border counties, um, for Spanish, an interpreter is the only requirement is that they be well versed in English and Spanish.
Thank you, Leo. We have another couple of questions that has to do with when the attorney understands that the interpreter is not, or believes the interpreter is not accurate. So here are both those questions. The first one is, when you know the interpreter has not translated accurately during the hearing, what do you do? Do you point it out to the court, request a pause to address it? You all discussed that, but I'm wondering if you have any additional tips that you'd like to share. The related question is, if I'm a Spanish-speaking attorney, how do I do my best to let the court know that the interpretation is not correct?
I object, right? As an attorney, you want to protect your client and make sure that they understand clearly what is being interpreted. So I immediately object. I object to the translation. I have never had a judge ask me to take, or I haven't asked to take the interpreter on voir dire, but Judge Griffin mentioned that on our chat, which I think it's a great idea to do. But when I've done it, I just let the judge know that I would like clarification on the translation, or I mean, the interpretation actually. And I go ahead and have a talk with the interpreter. And sometimes the judge has asked, well, do you have a better translation that you can offer, or a better interpretation? And I, add what I can, or the interpreter gives different words that they think are appropriate, and that would help. And that's the way that I've done it. The courts are usually very flexible with that.
I think that the trap that some folks fall into is thinking that it needs to be a word for word translation. And that was one of the things that I learned from this presentation. It's not exactly a word for word translation. But if the proper way, I think, to bring, if you have an issue with the translation, is to bring an objection. And normally what I would do is, if I thought that the objection was valid, I would admonish the translator and we would move forward. But on occasion, when we were preparing for this presentation, I thought, why not let the lawyer take the translator on voir dire to establish credentials if there is a serious concern about the translator's ability to translate accurately.
Thank you all. We have another comment that's been made in the chat about speed. Court reporters have one speed. Court interpreters also have to think and work very quickly. This person's comment is, sometimes asking people to speak slowly can be unsuccessful. So I'm wondering, Damaris, as an attorney or a judge, or Leo, how would you all handle it if it seems like the interpreter is having a difficult time keeping up with what's being said in court?
I make sure to instruct my client. I prepare my client well when I know that my client's going to need interpretation services, but they get nervous. So sometimes they do speak fast. And I've had occasions where the interpreter asks the client to stop so that they can interpret. I've had also times where I've stopped the client so that I stopped my client so that the interpreter could interpret. There have been times where the judge says, you're going too fast, you need to slow down. There have been times that the court reporter has told the client, you need to slow down. So I think anyone at the moment, but as the attorney, I think we should have control of our clients.
Judge Leo, anything that you want to add?
I would say, and it's somewhat related, but it would also be a good idea whenever, most definitely, speaking at a normal speed will help the interpreter keep up. But a lot of times also, the interpreter may not be able to keep up because they're not qualified to interpret in those types of hearings. So one of a good point for an attorney or for a court staff, whoever is procuring the services of that interpreter, is to ask them, do you have experience in CPS cases? In what other types of CPS settings have you interpreted for? Because the more they know of the court process in that type of a hearing, they'll already be familiar with the vocabulary that's going to come up, the terminology that's going to come up, and it'll help them keep up with the normal course of the hearing.
I think back to when I was a young lawyer practicing in Amarillo, the court reporter there and the judge there and proposed what they called the 1, 2, 3 rule on me. So you could ask a question, 1, 2, 3, ask your next question. So as a lawyer, as a judge, when you have a habit of talking too fast, ask your question, take a beat, ask your next question.
Thank you all. And along those lines, the person who wrote about this in the Q&A mentioned that a trick that she uses that she learned from a court reporter is to ask the party to focus on enunciating their words, because that's a different brain process and it kind of necessarily makes the speaker slow down a bit. The other question that we have that I wanted to pass on to you all is a question about what the going rates are per hour across the state. I'm imagining that's for when you need to hire an interpreter in a private case. Leo, do you know those offhand, or Judge Damaris, do you have any idea of what the going rates are?
I honestly think it's based on the interpreter. Some of them have their own prices. I mean, I have a person who does nothing but prove-ups, and he does $150 for a prove-up. I have some that have a $250 an hour and a minimum of 4 hours. Some do $250 an hour, don't have a minimum. I've had some who have been more than $250 an hour, which is why I have a long list.
And to add on to that, that's why we included it in the good practices is if you do hire an interpreter for the morning and they charging by the hour, if you're absolutely sure that your case is going to be called at 9 o'clock, 9 o'clock may not be the good time to ask them to be there. You might want to ask them, well, please be there at 10 o'clock and coordinate that, of course, with the court, my interpreter, or, knowing what time. But if you're just going to have the interpreter there idle from 9 o'clock to 10 o'clock, that's a full hours that you paid the interpreter that just went down the drain that you could have used for other things.
All right, thank you all. Thank you all viewers for the questions. Thank you speakers for your time. That's our time for today. On behalf of the Children's Commission, I'd like to thank Judge Griffin, Leo Perales, and Damaris Chavez for their very helpful and informative presentation. If there are any additional questions that our viewers have, please go ahead and contact the speakers directly. Their emails are on the slide. Thank you all for watching. The State Bar has approved this course on utilizing court interpreters in child welfare cases for 1 hour of MCLE credit. Those watching the replay of this course can contact CC training@texcourts.gov for the MCLE self-report information.